I've been practicing essentially from my last year during my college. So it's been almost 3 years, but if you take into consideration the practice after attainment of license, it's been about 2 years. और काफी अच्छा experience रहा है practice का भी और I've been adjudicating various international and national moot court competitions as well and participating in such competitions as well. So my basic forte is trial work, and on a hindsight, I do adjudicate moot court competitions as well.
Okay, so that was a very elaborate introduction. I am sure कि अगर हमारे viewers आपको contact करना चाहें for guidance, would you be open to that?
Yes, absolutely, absolutely. I've also been teaching law moots as a subject in Khalil Law College. So if anyone does need some sort of help in both trial work, criminal law regimes, or if mooting itself, then I'll be open to it.
Since we're starting very basic, the Constitution. So, how do you think Pakistan's Constitution protects individual rights to life, liberty, and security during armed conflicts with lawfare tactics? In the light of lawfare tactics, I would say.
All right. So the Constitution of Pakistan contains, specific provisions on the right of life, liberty, and the security of individuals, which can be invoked to safeguard civilians during armed conflict. Their utilization is another thing. Uh, but firstly, we do have to understand where does these rights come from, and what or how they are utilized, and where they are enumerated. Firstly, the right to life, which you have elaborated, is Article 9 of the Constitution. And as we all know that all the rights that are mentioned in the Constitution are constitutionally protected and cannot be abrogated under any circumstances, whether be it may be an armed conflict or a situation of peacetime. Well, the Article 9 of the Constitution guarantees the right to life. It further elaborates and states that no person shall be deprived of life or liberty, or that the next part of this particular provision says that save in accordance with law, which means that this is not an absolute right, it's a conditional right. जैसे अगर for instance if a person has murdered an individual, he cannot disguise himself under the protection provided by the Constitution. This right is subject to law. The utilization of this particular right can be evidently seen and as elaborated in various conventions or various enactments. For instance, the section which comes at the top of my head is Section 491 of the CrPc, or Article 199, writ of habeas corpus. For instance, if any individual has been deprived or detained unlawfully, illegally, he can file a petition of habeas corpus before the Court of Sessions or the Court of High Court to, curtail that detainment, that illegal detainment, or the threat to life which he himself faces at the time. A right to liberty or जो right to life है, that are to some extent correlated with each other, because इस right to life और right to liberty की दोनों की जो curtailment है या detainment है, या if you feel like your right to liberty has been abrogated, you can file uh, similarly a writ of habeas corpus in the court of session or the court of high court, and the courts will ensure that your right to life or liberty is not curtailed unlawfully, because all these rights which are in chapter 2 of the Constitution are subject to law. No right is absolutely absolute in its nature. During armed conflicts, where lawfare might be employed to target specific individuals or groups, these particular provisions can be invoked to ensure the individuals are not unlawfully detained or subject to arbitrary arrest. It allows the detainees to challenge the legality of their detention before the court of law. Thirdly, you asked me about the right of security, right?
Yeah.
So, although the Constitution does not explicitly mentions the right to security, it merely provides a provision for the protection of the citizens against for the maintenance of public order. For instance, the Article 4 that mandates the state that the state shall, in accordance with the requirements of justice, provide a free and secure environment to the people. And additionally, Article 9, which you have already discussed, ensures the right of right and liberty, which inherently, encompasses the right to security. So these provisions can essentially be invoked to demand the state to take necessary steps to protect civilians during armed conflict. and to prevent lawfare tactics that put the civilians' lives at risk. Because we do believe in the practice of judicial system that the courts are acting as guardians of the constitution and can interfere at any times to safeguard the right of civilians and can even order investigations into human rights violation. For instance, a very case law that comes at the top of my head is the enforced disappearances cases that is ongoing from all, I believe, 2007 or 2008 in the Supreme Court. So the Supreme Court in that particular case have ordered on a number of time inquiries from independent institutions to collect the data and submit it for that might be up to their satisfaction or not, so they can take a legal action upon it. These intervention essentially can help deter lawfare tactics and ensure the protection of civilian rights during armed conflicts.
ओके यहाँ आपने काफी इंटरेस्टिंग बात की है जो सिक्योरिटी के बारे में आपने कहा है वो राइट ऑफ सिक्योरिटी उसकी सिर्फ प्रोविजन है इट्स नॉट आई वुड से कि उतना सब्सटेंशियली प्रोवाइड इन द कॉन्स्टिट्यूशन एज इट शुड बी आई थिंक व्हाट वुड यू से
यस इट्स जैसे बाकी सारी प्रोविजंस हैं एक्सपेशली मेंटेन की गई हैं आई बिलीव दिस इज अ प्रोविजन व्हिच नीड्स टू यू नो get an elaboration in the form of an enactment or a constitutional amendment because the right to security is as I've explained earlier not expressly been provided in the constitution. We can just merely draw an inference in light of article 4, 9 and 10 that the right of security does exist but it needs a clear legislation upon the particular matter.
Is how do Pakistan's internationally ratified conventions on human rights laws and international humanitarian laws interact with the domestic law framework of Pakistan concerning the lawfare?
All right. So, Pakistan's ratification of international conventions that are related to human rights or humanitarian laws established uh, at both international and domestic level. These international obligations interact with the domestic legal regime in multiple ways, particularly in cases that are, involving regarding the doctrine of lawfare. For instance, when Pakistan ratifies international conventions, it may incorporate their provisions into domestic law. First of all, we have to look upon the difference between the ratification and being a signatory. When one state essentially becomes a signatory to a convention, it does not necessarily require itself to incorporate that particular law into their domestic regime. But since or when the state does ratifies the treaty, it then has to incorporate those particular laws in their domestic regime. For instance, if we look at ICCPR, and we may find a resemblance in the rights that are provided in that particular treaty, similar to the rights that are provided in Constitution of Pakistan, Chapter 1, Part 2, Fundamental Rights, Article 8 to 28, which elaborates in depth the whole uh, constitutional rights that are protected by the Constitution itself. Once these laws are incorporated, international obligations become a part of Pakistan domestic legal framework and can be directly invoked and enforced by the individual institutions in the country. The big question which arises at this point is that how a direct application can be seen evidently when the state recognizes or ratifies a treaty. In some cases, international conventions, including those that are related to IHL or IHRL, may have a direct application in domestic courts, even without the explicit incorporation. As I've explained earlier, that if you look at the rights that are provided in ICCPR, you may find a resemblance with those rights that are mentioned in the Constitution. So even though, if for the sake of discussion, we may consider that these laws are not applicable in Pakistan directly, but we can see indirect, uncanny resemblance. This means that individuals can directly rely on these provisions of international treaties during legal proceedings, and domestic courts are, obligated to consider and apply the provisions in their judgments. Furthermore, uh, we may see also a harmonization with domestic courts regarding the international standards to, ensure consistency and compliance. For instance, if we look at a very famous case that was brought to International Court of Justice by India, the Kulbhushan Yadav case, he was actually a espionage and couldn't be dealt in accordance with the laws that are provided to regulate the judicial system of Pakistan. So international conventions and treaties came into play because the Pakistan has ratified the ICJ statute. So there have been plenty other numerous instances where we can see that during the scenarios of lawfare, both international and national enactments can be interlinked or can be seen into force either directly or indirectly.
You
Right.
just mentioned that when a state is a signatory of an international convention, it becomes obliged to make it a part of their domestic framework, or at least to help maintain their domestic framework in continuance or in conformity with that international obligation. Some people say that
Right.
the legitimacy of international law is subject to the question of acceptance by the people, the constitutionality of international law. How can we say that a
Right.
law which has not been recognized by the people of a state, or at least not made by the people who are representatives of a group of people, can be applied to that group of people? So, in short, my question is, how do you look at the question of legitimacy of international law?
Firstly, what I earlier told you was that being a signatory merely does not binds a state to incorporate that particular law into their domestic regime. Merely ratifying the treaty or an enactment does binds the state to incorporate that particular enactment into their domestic regime. Thirdly, there is no as such comprehensive answer with respect to the individuals who are not feeling themselves bound by that particular regime. As a state, the state has international obligations which they have to fulfill, and if they do not comply with those obligations, they may face serious repercussions. For instance, let's just take the example of Russia. uh, they or Russia or Iran, we can take either of the example. They feel like they do not, feel bind themselves with respect to the international conventions or treaties. So for a number of years, they have been facing international sanctions and particular uh, repercussions as well, if you say so, for not obliging with those particular international conventions. So one cannot say that he does not feel. One cannot wake up and say that he does not feels like obliging with these particular treaties or enactments, be it in a domestic law or an international law. Obligation of a law is a compulsory requirement which has to be fulfilled at the time.
I want your take on this. Can you give us one example from our constitutional history where you think कि हमारी constitution provisions को use किया गया था to challenge lawfare या maybe prevent human rights abuses in armed conflicts?
Right, surely there have been several examples from Pakistan, legal history where constitutional provisions have been utilized to challenge or prevent instances of lawfare or human rights abuses during armed conflict. Notable few examples would be a case of Maulvi Tamizuddin Khan, 1954, in which Maulvi Tamizuddin Khan, who actually the constitutional dispute arose when the Governor General of the dissolved Constituent Assembly, 1954, Maulvi Tamizuddin Khan, who was the Speaker of the Constituent Assembly, challenged the dissolution of unconstitutionality. The case went to the Sindh High Court, which held that the dissolution was indeed unconstitutional and violated the fundamental rights of the members of the assembly. This played a very significant role. However, this decision was again turned by the Superior Court. So this is considered as a black mark on the history of constitutional development. Another example which I would like to quote is the era in which the judicial activism was during the times of martial law was invoked. That is the time between 1980s and 2000s. During the military dictatorship in Pakistan in the 1980s and early 2000s, the judiciary played a very crucial role. For instance, a case which comes at the top of my head is the Asma Jilani case, where it was essentially presumed that a doctrine of necessity was thrown out by the Superior Court by then Chief Justice at the time. And on a number of occasions, the Chief Justice Iftikhar Muhammad Chaudhry, during his tenure in 2005 to 2013, has actively intervene in the cases, and for instance, the cases of enforced disappearances and illegal detentions, using the constitutional provisions to protect the rights of individuals that were at the time being affected by the state actions. Missing persons case 2007, and that is going on till date, is another example where the issue of enforced disappearances during armed conflict in Balochistan has been challenged by has been a significant challenge essentially for Pakistani societies. Families have been reaching the Supreme Court for missing persons, and they have been utilizing the constitutional provisions such as the right to life, liberty, and dignity to challenge these human rights abuses. These are the same rights which we discussed at the earlier part of this interview. And the court has actually repeatedly called upon the state institutions to provide evidence and address the issue of missing persons, emphasizing the need to respect the rule of law and constitutional rights. Another example is the protection of women rights during the armed conflict. A very landmark case is the Mukhtara Mai case, who was a survivor of sexual assault during these times of armed conflict, and she sought justice through the courts, arguing that violation of her rights was a violation of constitutional guarantees of equal protection and dignity. The right of equal protection and dignity, Article 14 and Article 25 provides the right of equality, for the reference. These are a number of examples which highlight some instances where, constitutional provisions were utilized to challenge or to prevent instances of lawfare or human rights abuse. It depicts a very significant role of the judiciary in upholding the constitution at a number of times and protecting the rights of individuals, even when the circumstances were quite challenging to them.
मुझे अहमर आई थिंक आपको भी वो याद आ गया होगा जो हमारा सब्जेक्ट नहीं है कॉन्स्टिट्यूशनल हिस्ट्री वाला. इट वाज अ रोलर कोस्टर जुडिशरी को देखना कैसे डॉक्ट्रिन ऑफ नेसेसिटी को अब्यूज किया गया था. हम तो क्लास में बैठे ऐसे हो रहे थे ये हो क्या रहा है. तो दैट जस्ट ब्रॉट अ लॉट ऑफ मेमोरीज बैक. तो Khalil, where do you think the missing person cases is going? 2007 से चल रहा है. Where do you think it's going up? What's your take on
You
it?
know, as far as my personal opinion goes, हम सबके साथ ये मसला रहा है कि हम लोगों को पहले लगता था कि द मिसिंग पर्सन केस और एनी ऑफ द एट्रोसिटीज दैट हैपेंड गोइंग ऑन इन द बलोचिस्तान इज जस्ट अ हॉक्स, एंड एवरीथिंग इज जस्ट फाइन देयर, और ऐसा कोई मसला नहीं है, सब कुछ ठीक चल रहा है स्टेट में. बट सिंस we have been studying law and reading the reports about it of international organization, we came to a realization that this is not a hoax and this is something that needs to be addressed clearly. Uh, Although we do have clear instructions and clear provisions in the Charter of the Land, which is the Constitution of Pakistan, to provide equality or right to life, right to dignity, but there have been certain challenges, and we do know what is the sole reason of those challenges. We might not be able to discuss those challenges at this time because वो थोड़ा सा ग्रे एरिया है, और उसके ऊपर जो है ना, आपको पता ही है आजकल क्या मसले मसाइल होते हैं, जो बात करता है उसके साथ क्या नतीजा होता है इसका. बट आई फील लाइक फ्रॉम माई पर्सनल पॉइंट ऑफ व्यू इसको एडजुडिकेट होके एक फाइनलाइजेशन तक पहुंचना तो चाहिए, बट आई फील लाइक इट्स नॉट गोइंग एनीवेयर, or it's not going to go anywhere in the near future. It's the unfortunate reality of it, with having all the provisions and all the relevant law that one needs to apply to adjudicate such matters. We still are facing legal consequences and facing other difficulties which hinders or limits the ability of the judges to adjudicate on such sensitive matters, unfortunately.
We all know that lawfare can be used positively and negatively, but we see that in Pakistan, people who are in power use the provisions of containing the lawfare characteristics to shut the mouths of those who speak against them, or to stop them from politically criticizing them. So, do you think
Right.
that the Pakistan's legal framework should provide or does provide any legal provisions which provide people with the right to speak against people who suppress them, or does Pakistan lack that feature in its legal framework?
अहमर ने अपनी जान पे खेल के ये सवाल किया सबके सामने बैठ के.
As we have discussed earlier, that Pakistan legal system has the provisions, to address and protect the right of freedom of expression and all the rights which are, enshrined in the Part 2 of the Constitution. under the chapter of fundamental rights. The question is not whether legal provisions are provided in the law. The question is the respect to their applicability in normal scenarios as well as scenarios of lawfare. As we have seen previously, a very notorious incident which has been highlighted for ongoing last 2 months, the incident of 9th May. And we see a number of instances even during the court's proceedings as well, where even the judges know that this individual has nothing to do with the case. But because of out of course or some difficulties which we cannot yet again discuss, they are unable to adjudicate upon the matters. Although the constitutional is protecting those rights, for instance, the freedom of speech and expression that you talked about is mentioned in Article 19. And this fundamental right applies to all the citizens and provides a basis for the challenging any attempt to suppress or curtail the freedom of such individuals. And one more remedy which has also been provided is the judicial safeguard. The judiciary also plays a crucial role in protecting the rights of individuals and addressing the abuses in the name of lawfare. Pakistan courts have, recognized the importance of freedom of expression, have taken steps to safeguard it as well. And a notable example of which is Asma Jilani case once again. But they have overturned laws and ordinances that were deemed to be against constitutional guarantees of free speech and have issued judgments that were upholding the right to criticize the government and political opponents within the bounds of law. But still, yet still, where there is an opportunity, there are certain challenges as well. So the question with respect to new legislation is not, I believe, apt enough. We do have legislation, we do have certain sets of rights and laws which do ensure the protection of rights which are mentioned in the constitution, but the main hindrance which one face is the applicability of those particular laws. Let me give you a very personal example of it. I've been conducting trials of those individuals who were arrested in the incident of 9th of May 2023. There has not been a single iota of evidence against individuals. They even have arrested those individuals which were not even present at the time of the incident. Another notable example is the MPO, Maintenance of Public Order, which was enacted in 1960, and law that was made by the dictator to protect his illegal adventures. And we see the applicability of such law in the modern day and age as well. If we look at the example of the ex-MNA, the Sharia Afridi, we have seen that he has been arrested for more than 7 or 8 times under the disguise of that maintenance of public order. So that essentially is also an example of lawfare as well. So the question with respect to the presence of such law is we can say that these laws do present themselves, but there is a functional problem in their applicability, and the judiciary itself is, have their hands cut off from such instances to enforce those rights.
Law is a tool to be used by the one who is in power. So, what do you say about it?
Precisely. At least I don't know talk about the other legal systems that are around the globe, but if we talk about our legal system, what you said is quite aptly true. The law here is just become a tool for the powerful to use and utilize and suppress those individuals which are, which do not have the essential remedy or, so to speak, the luxury of utilizing the law in their favor or affording such big lawyers which have hefty fees or big lawyers or big names, so to speak. One more example which we have discussed earlier is the Balochistan missing persons case as well. Those individuals are suppressed, their families are not able to afford such lawyers which are big names in our country, so to speak. And moreover, if they do afford those big names as well, the judiciary cannot do nothing about it. So we can agree upon the certain factor that there is only one powerful individual that is sitting in our country, and the law has for so long became a tool of that powerful entity, and that entity has also exploited the law since the last 75 or 6 years.
What do you think is the way out? So, I mean, our purpose of this organization is to let the common people know that we are with you. We are supporting you guys in this situation where no one is ready to listen to you. We are your hope. So, what do you suggest us? What is the way out of such a situation where no one listens to a person who does not have power, but only law in his hand?
Law is something which is a tool which can both be used as positively or negatively. Since this initiative is to discuss about the endeavors of law in a positive manner, what I would suggest to you guys is जैसे अभी आपने देखा कि after the regime of Imran Khan, people have acquired a certain criteria of political knowledge, and they are quite aware of the things that people back in the day were not used to. And any revolution that comes in any state or any culture cannot come in a very short span of time. It has to take decades. For instance, if we look at the revolution of Iran, so it was extending about 30 to 40 years when the revolution came about. So what we can essentially do is कि इसी तरह के topics पे which are controversial in their nature, and we can hold discussions and arrangements, and we can also provide, which I do myself personally as well. I go to the jails and I do pro bono cases as well for those individuals who are not privileged enough to you किसी वकील को एंगेज करने के लिए उनके पास इतने खास कोई पैसे वैसे नहीं है तो जो यंग जनरेशन है which is coming around the block does need to indulge themselves in such activities, and especially when you have the manpower or financial expertise behind you, और कतरा कतरा करके ही दरिया बनता है तो in the end I believe that this is a very good initiative, and these sort of initiatives are the dire need of this particular hour. और अगर हम इसी तरह इस रास्ते पे चलते रहे तो आई एम होपफुल that one day we will see our country in a very very prosper and better situation.